live from the On the Bench studios at the Low-Mat offices. It's On the Bench with your hosts, Melissa A. Day and Shannan M. Mackey. And now here's your hosts, Melissa A. Day and Shannan M. Mackey.
She achieved her master's working with Teach for America, and she obtained her Juris Doctor at Albany Law. She's what I refer to as a special funds survivor, and I think that Shannan was really groundbreaking and a trailblazer in the litigation on the opioid issue. Do you think that that's going too far, Shannan?
No, we at Special Funds had a lot of those cases and really pushed them prior to 2014 when the new guidelines came out, back when it was the Wild West of opioid narcotics.
And we appreciate it. Thank you. And then I'd also like to just throw in that Shannan is also the mother of the fabulous Cameron, who I haven't had an opportunity to meet yet, but I feel like I know already. She's a fashion maven.
Yes.
She's all girl, except when it comes to sports, it sounds like.
She loves softball and swimming.
Well, that's great. And Shannan lives in the Southern Tier in the Chautauqua County area, correct?
Yes.
All right. So thank you. We're glad to have you aboard, Shannan.
Thank you.
Next. So today's news, the scoops, dishes, and rumors and gossip that we want to talk to you about, we're going to start with the new fee schedule. So the board issued the new proposed fee schedule pursuant to the requirements of our Administrative Procedure Act, which requires that when new regulations are promulgated, we have to have a public comment period. And so the board issued a proposed new fee schedule on June 6th of this year that triggered a 60-day comment period. And following the closure of the comment period, the board went back to the drawing board and started doing some revisions. And we now have what is the board has presented to the public as the final version, which triggers another 30-day comment period under the Administrative Procedure Act. And so we are still within the comment period in order to provide further comments about the new fee schedule. So I would request that people, especially you adjusters out there whose knowledge about the rules and the localities and how the working with the fee schedule actually occurs in real practice, which is much beyond my skill level, that you go and take a look at the new fee schedule. There was one thing that I thought was particularly interesting from our perspective regarding chiropractic and physical therapy visits, which now puts a limit on receipt of 12 visits within 180 days of the first or of the date of accident, which seems to me to be a significant change from what we'd previously encountered. Now, given our medical treatment guidelines and the rules for requesting variances, I would think that providers could still avail themselves of the variance procedure to request additional physical therapy or chiropractic visits. How do you feel about that?
Well, I think there's not really much of a change from these based on the medical treatment guidelines already in place.
Mm-hmm. Okay. So if you have comments, now would be the time to go to the board's website and to review the new proposed fee schedule, because I anticipate that if there isn't anything dramatic that the public or the stakeholders provide as a comment within the next 30 days, that this is going to be the final version of the fee schedule. Next. Along the same lines, the board has now issued its second proposed prescription formulary. So it's taken a little bit longer for the board to get out its second version. If you recall, at the end of last year, the board promulgated its initial version of the formulary, and just recently, again, as with the fee schedule, we've seen our now second revised version of the formulary. So we are, as we are with the fee schedule, we are still within the 30-day comment period for the new formulary. And so again, I would encourage you to go to the board's website and to review the proposed formulary and to make comments about it. In very general terms, without getting super down in the weeds about what the formulary does, it provides for 4 different lists for when a prescription would be appropriate for treating an occupational injury. And so there's a list of the Phase A list describes prescriptions that are appropriate during the first 7 days after an injury. Phase B talks about prescriptions that are appropriate from the 8th day until the 30th day, and then Phase C discusses medications that it would be appropriate on a longer term basis. The fourth list that is included in the formulary is for perioperative procedures. The effective date for the new formulary, once it's finally adopted by the board, will be 6 months for new prescriptions and 12 months for refills. So we're looking forward to the formulary. I do believe that, like the medical treatment guidelines and for the body sites, the neck, the spine, the shoulder, the knee, and for non-acute pain, it's my anticipation that the formulary should help us control costs by limiting the prescriptions that the doctors can use without a variance.
Yeah, I think this is going to be a good step towards the downward trend in opioid narcotic litigation specifically and prescriptions. I mean, New York State is down 17% since last year in those prescriptions, and I think this will help keep those costs down and keep those new prescriptions and hopefully further refills down.
As long as the cost of medical marijuana doesn't skyrocket, because it seems that that's where we're moving next as far as both non-acute pain and acute pain. As the New York State just recently passed the inclusion of marijuana as an option for acute pain treatment as well as non-acute pain. Next. Our next segment of the dishes, scoops, and rumors about the board is the third department did what? As you know from our news program from this summer, when Mr. Caggiano and I discussed this third department decision of Tahir versus Iota Taxi, we informed you at that time that both the board and defendants in this decision filed either a motion for reconsideration or a motion for leave to appeal to the Court of Appeals. So the defendants, the respondents who lost in this case, as well as the Workers' Compensation Board, are seeking a change in this decision, which is somewhat unusual. And if you recall, and to hear, the third department found that if you have both schedulable and non-schedulable conditions, and that if at the time that you are at MMI, you are not entitled to an award for the non-schedulable condition, and your schedulable condition is amenable to a schedule loss of use award because you're at MMI for that condition, that there's nothing that prevents the claimant from getting a schedule, despite the fact that ultimately they're going to likely receive a non-schedule award. So really this kind of turns the law for schedulable and non-schedulable conditions on its head and is not consistent with how the board had been interpreting the applicable provisions of Section 15. So what happened is the board has filed a motion for leave to appeal to the Court of Appeals. Defendants have filed a motion for reconsideration. And what is so interesting about this Tahir decision is a decision that was decided simultaneously, and that's the Tobin versus Finger Lakes DDSO claim. And in fact, David Wertheim, who's general counsel for the Workers' Compensation Board, recently did a presentation at the Buffalo Claims Association Education Day, and he discussed how these two decisions seem to be inconsistent with one another. The Tobin decision, and I just want to read this quote directly from the case, says that a claimant may not receive both a schedule loss of use award and a non-schedule permanent partial disability award for injuries arising out of the same work-related accident. So, and then they cite Tahir in the Tobin decision. So it's difficult for me to reconcile these two opinions and the reliance on Tahir in Tobin to find that you cannot receive a schedule award and a non-schedule award for injuries arising out of the same work-related accident. I'm really having trouble trying to figure out how the third department is going to be able to reconcile those two decisions. So we'll have to see where what the court does with the either the motion for leave to appeal to the Court of Appeals or the defendant's motion for reconsideration. It's possible that the third department may come back with an amended decision on the Tahir case. I did have one more interesting case that I wanted to touch on from the third department. So the third department did something kind of what we find to be inconsistent with the way we've always practiced at the board. And that seems to be exacerbated by its decision in Tobin, but reached a great result, especially from the defense bar's perspective in the, how did you say that?
I said Genduso, but I don't know that that's correct.
Genduso claim, which I think is going to be very helpful for us. And in that, do you want to explain a little bit about what happened in that case?
In that case, the claimant had multiple claims, and those claims had different sites of injury, but all on the same schedulable body part for, I believe it was the left leg, so I believe it was like a left leg and a left ankle claim. And the board found that the left leg is just one entity, even though it's different claims. So you can't then have an overall schedule that's increased in the left leg because of those different individual body sites. I think it was a great decision. I had a case that we were litigating pretty heavily where the overall schedule loss of use for the right arm for this claimant's 4 injury sites was 155% schedule loss of use, and he still had an arm that he could use very well. So I think this was actually a great decision from that perspective.
It's an interesting decision. It does correct what seemed to be a logical impossibility that somebody could lose more than 100% of an extremity. And so just to reiterate, so you have a knee injury, that leads to a schedule loss of use of the leg. When you have a subsequent claim that involves a hip injury, in the past it's been that you would receive the additional schedule for the hip or for the leg as a result of the hip injury completely independently of what had previously happened on the knee injury. Now, if you have the subsequent hip claim, when it comes time to schedule, you're going to be able to take a credit against whatever the schedule is for the hip as a result of the permanency to the knee. So this sort of, I think, sets right the ship with respect to whether or not it's logical that you could receive in excess of 100% of an extremity. Although I would note that the guidelines themselves do provide an example of how that could be possible, but the third department either felt that was not applicable to the overall determination of what the permanence should be, or perhaps they've overlooked it. That is possible. Next. Yesterday, the board issued a press release about its virtual hearings program. As many of you, I'm sure, know, the board has moved to holding its hearings by video conference, essentially. And so the parties to the hearing can participate simply by logging onto a website, entering in their virtual hearing ID number, and if you have video capability with whatever device you're using, you'll be able to see a video of the judge and the other parties who are participating by video, and you can also broadcast a video of yourself as long as you have that capability on your device. Essentially, this has been implemented statewide, and this is here to stay. The board is very proud of this conversion to virtual hearings. So the resistance is futile, basically, downstate. I do understand that the bar downstate has pushed back on the implementation of virtual hearings, but personally, I think it's fantastic. And I've put up a couple of exceptions to how the virtual hearings have been implemented statewide. There are at least 2 locations that are not able to participate in that technology because of the remoteness of their locations. And Shannon tells me that there's also potentially a location in New York City where the virtual hearings program isn't running yet.
I believe Long Island. I believe it's Hauppauge is not virtual either, and New Windsor is Newburgh. It's
in my mind, that's remote. I'm sure they probably have more people in Newburgh area than we have here in all of Western New York. However, We all know that everything good happens here, right? From my perspective, the convenience of virtual hearings is fantastic. I can be waiting for a virtual hearing to be called while I'm working on another file. I can also have up the board file, the board's e-case, and access that pretty easily now while I'm appearing at a case or on a file virtually. This is saving our clients money because from our perspective, we bill hourly. So if we're not having to travel, we don't have downtime at a actual hearing location. I don't expect my attorneys to just show up right when the hearing is scheduled. You need to show up a couple of minutes early, and again, that can lead to inefficiency and increased cost. So from our perspective, we believe that it's helping our clients to save money. The board's program is pretty groundbreaking and is being used as a sample for other agencies across the country for how they can start to implement virtual hearings for the adjudication of their kinds of claims. And in addition to what has already been implemented, which includes now the ability to access the system from international phone numbers or to call an international phone number, there is a phone app coming. Although I have to tell you that right now I've been able to run a virtual hearing from my phone without an app, simply by accessing the board's website, and then you do have to download a Citrix app, but it hasn't really been any issue at all. And that's somewhat surprising given the demands of having to transmit a video, image, and sound over a cell network. So from my perspective, the board has a right to be proud of its virtual hearing system. And next, as you might guess, the law offices of Melissa Ann Day is now appearing statewide as a result of the virtual system. And if you have claims downstate or anywhere across the state, we can definitely help you out with those. Next. Many of you, I'm sure, are familiar with the board's very aggressive stance in denying appeals. The board issued a subject number, I believe it was in December of 2016, and they promulgated a new RB 89 and RB 89.1 at the time, which required some additional details, and the board also indicated in its subject number that it would require strict adherence and that all the form for an appeal be that it be fully completed in order for it to be considered proper and in order for the appeal not to be denied. And so following that subject number, there have been a spate of denied appeals. And we certainly suspect that one of the motivating factors by the board in promulgating this new form and requiring such strict compliance with the new RB 89 was to have the secondary benefit of being able to whittle away at the backlog of appeals that were pending at the Appellate Review Division. I don't have numbers in front of me, but I don't think it would be challenging for me to find some substantiation that statistically that the board's census of cases waiting a decision from a 3-commissioner member of a board panel has dropped dramatically over the past year and a half or so.
I definitely noticed my appeals coming back faster from the board and the full board.
And I have as well, and I think that is as a function of the board, the fact that the census of appeals that the board has to decide is smaller, and so they're getting to things more quickly. Not that you can still wait quite a long time on some appeals. So I've had that experience as well. And as I mentioned, we both attended a education day last week that was sponsored by the Buffalo Claims Association, and General Counsel Wertheim spoke at the presentation, and he informed the audience that a new subject number on strict compliance with the RB89, and a new RB89 is my recollection.
Yes, I believe in a new form.
Is imminent. And in fact, he stated at the conference that he expected the new subject number regarding appeals, applications for review, and rebuttals to have been released early this week. Since it's Friday, I don't think that the board met that, obviously, expectation. But regardless, we do expect there to be a new subject number on the filing of applications for review and rebuttals in the very near future. And I think that based on his comments, General Counsel Wertheim's comments at the conference, I do not expect that this will remediate any past issues with appeal denials, unfortunately. So if you had an appeal denied in the past, even if you have an application for review, an application for full board review pending, I am not optimistic that the new subject number will address your particular issue. However, I do have to say that there was a decision issued by the Appellate Division yesterday, and General Counsel Wertheim also informed the audience that there's an appeal pending on the denial of applications for review at the Appellate Division, and he expects a decision on that case within the next 4 months. And it's possible that Appellate Division decision might affect some of the appeals that have been previously denied. The decision that came down yesterday from the Third Department is in the matter of Gene Johnson versus Alltown Central Transportation. And while the facts of this case, of course, are specific to this claim and this claim only, I think it might be illustrative of where the court is going on these types of decisions, although not necessarily predictive. In Johnson, the claimant's attorney filed an application for review using the old RB89 form approximately a week after the board issued its new subject number with the new form that it had promulgated, and the subject number indicating that the new form had to be used. It was 5 business days is how it was described. The parties agreed, even the carrier conceded on appeal, that the information that was contained on the new form was substantially similar to the old form. But the subject number does say that the board can deny the appeal if the new form isn't used. And after reviewing the process for filing an RB89 and noting the history with respect to the promulgation of a new form, the court found that the board should not have denied the claimant's appeal, that they should have considered it, given that there was no prejudice to either the carrier or the board, which was interesting. And it was also significant to the court that the Attorney General did not file a brief in support of the board's decision below. So as I'm sure many of you know, the Attorney General's office represents the board on appeals to the Third Department, and they file a brief generally in support of whatever the decision was below by the board. So they act as the board's attorney at the Appellate Division. And the court found it significant in this case that the Attorney General's office did not file a brief, in essence saying that they did not feel that the decision was defensible. So as a result, the Appellate Division reversed the board's denial, and so that litigant will have their day in court. I would also note that on this particular issue, there are mandatory full board reviews pending, and they are as a result of the dissent of one of the commissioners in connection with a 3-member panel of the board reviewing the issue. And the commissioner who has been dissenting on some of these cases is Commissioner Levelt. I'm not sure how to pronounce her name. It's Ursula, Levelt. And when she dissents, it's because she finds in some cases such a substantial property interest that's the subject of the appeal that she would not elevate form over substance in denying the application for review despite a technical defect with the compliance with the board's instructions or the subject number that was issued. And so our office has, and I know there are other appeals pending, an application for mandatory full board review, which is to be distinguished from those for discretionary full board review, where one of the commissioners dissented, and that does give us a right to the full board's review of the decision. So I think that the board is probably tabling those decisions until such time that the appellate division speaks to this issue again, as described by General Counsel Wertheim. James Cousins in our office reached out to General Counsel Wertheim, I believe, and confirmed that the decision that came down yesterday is not the appellate division decision that he was referencing at our conference. So we believe that there is still another decision out there that will be decided within the next 4 months or so, which may provide us with additional guidance on this issue. All right, next, please. The next thing I wanted to talk about was the extreme hardship redetermination. So we had reforms in 2007. Did you know about those?
Yes, I did.
Were you born yet?
Yes. I was teaching little kids to read.
Were you one of the little kids?
No.
No, okay. So extreme hardship redetermination. This is a result of the 2007 reforms, which found that at that time, that if you were classified with a loss of wage earning capacity in excess of 85%, that upon cessation of the caps, you could apply for to have your disability reclassified as a permanent total industrial disability or permanent total disability as a result of extreme hardship. The board or the legislature then amended the statute to change the LWEC percentage from 85% down to an excess of 75%. And they did an interesting thing and made it retroactive. And whether or not it seems that should have been allowed or not is a subject for a different dish. But what I will tell you about the extreme hardship redetermination for the claims where the LWEC was greater than 75% is we're starting to see those cases now. So those were cases where your loss of wage earning capacity would be in excess of 450 weeks or 400 weeks. I don't know those off the top of my head. I always have to look up. But regardless, claims that had a date of accident after 2007 are starting to appear in front of the board on whether or not the claimant meets the extreme hardship redetermination. And as the board does, it issued a subject number on what you need to do in order to qualify for the extreme hardship redetermination. And what claimants have to do is they have to file a form, of course, and that's Form C-35. And the standard that the board looks at is whether or not the individual has encountered a hardship that exceeds the usual or expected. The Form C-35 requires the individual to list their household income from all sources and also to detail their expenses. And the guidance that we've received on this already, which is the subject number it's on the board's website, and the case is one of the seminal cases of the board is this case Lincoln Hospital. And if anybody wants a copy of that case, I'd be glad to provide it to you after the presentation. But what the board has said with respect to the proof of your income and your expenses is that you have to have documentation. It has to be attached to the Form C-35. So, for example, I had a hearing yesterday where the claimant had submitted their C-35 requesting to be reclassified as total industrial or as permanently and totally disabled. And because the claimant had failed to attach all of the documentation substantiating his expenses as well as his income, the judge denied that application and said that he would have to resubmit. Now, what's interesting about that is that if the claimant attempts to resubmit, it's possible that he may not resubmit within 1 year of the expiration of the caps. So the original application might have been within 1 year of the expiration of the caps and been denied as being defective. And then what will be interesting to see is if the board tolls the time in which to file the C-35 if, once the claimant submits all the required documentation. Knowing the board as I do, I suspect that the board may find that the time in which to file your C-35 is told if prior to the expiration of 1 year prior to the caps, you file an application which is determined to be defective, and then you refile 1 year after expiration.
They did not do that with the C-250s when they had the deadlines for 15.8 claims when they found them to be defective.
Yes. The distinction probably, though, would be that was a fight between special funds and the carrier or the employer, and this would affect the claimant's rights to get reclassified.
Those ameliorative.
Correct. I would also note that the board panel decision that I found on this issue says that other factors must be listed on the form. So in addition to the extreme financial hardship, the judge can also take into account those wonderful nebulous other factors, just like we have when determining somebody's loss of wage earning capacity, which is not defined. However, what I think is good from our perspective is that the claimant has to have listed those other factors actually on the C-35. So if they're not there, then I would make the argument that they cannot be litigated because they're not already there. I would also note that as a practice pointer, I found evidence that was relevant on this C-35 issue yesterday in an attending physician's report, and it wasn't just the individual's degree of disability or how disabled they were. It was a mention by the attending physician that the claimant lived with his parents. And the C-35 did not include any income from the claimant's parents, who were undoubtedly had to have been on Social Security because of the age of the claimant. So I pointed to that fact that the doctor listed the claimant's parents as individuals who are also living in the household with him as part of our application for the defective C-35, and the judge did find that the C-35 was defective. So this is a question that we may want to have our IME doctors address, is to ascertain more than just what kind of activities of daily living can you participate in. We want our IME doctors, especially if this is an issue that might come up, to also question the claimant about who they're living with.
And would that then, you think, the C-35 on itself before the litigation, would that then form a basis for later fraud, or would you need it to be?
I think that's a great point. I think that this does open up a new avenue of potential fraud for people seeking the extreme hardship redetermination. That if they're lying about who lives with them, if they're lying about their household income. I mean, this gentleman too, I had ascertained that he purchased a home in March of this year, which in my mind suggests that he has some credit worthiness and a sufficient amount of income in order to be able to qualify for, in all likelihood, unless he paid cash, in which case I want to know about that too. But just by doing a Google search, I was able to ascertain that he'd closed on a home in March of 2018. These are situations where if somebody's lying about the sources of their income, our fraud investigations are going to take on a little bit different tact and may require more use of the subpoena power, but absolutely think that people could commit fraud in new and different ways with respect to whether or not they qualify for the extreme hardship. Next. So I just wanted to throw out some helpful hints, things that I find very useful in my day-to-day practice. One of those things is that submitting forms to the board by email is extremely convenient. You just send it to WCB claims filing at wcb.ny.gov. I know that the board also accepts a direct upload of documents to the electronic case folder. I guess I'm a little old-fashioned, and I like using the email because I retain a copy of the sent email, where I feel a little unsettled when I upload something to the board directly. I don't have that confirmation the way I do when I just retain my email. And I mean, I'll probably someday get over that, but for right now, sending things by email provides me with a level of comfort.
I like the email too, and I send it delivery and opening receipt as
Oh,
well,
really?
because I'm a little paranoid on that one.
That's why we love you, Shannon. That's why you're here. And that there's a variety of different file formats that will be, Najee's going to just back us up for a second. There are a variety of different file formats that the board will accept, and that includes Word documents, text files, GIF. Is it GIF or GIF? I always have this debate with my son.
GIF?
GIF. I have a computer, somebody that I would defer to, who's 20 years younger than me, is giving me assurances that it's GIF. And JPEGs, in addition to PowerPoints, which is kind of interesting, will be accepted by the board by email. You have to have 25 pages or less. It doesn't say whether or not that's an aggregate or not, because you can attach multiple documents. So I would err on the safe side for that. And your attachments can't exceed 20 megabytes. And you're not going to necessarily get an error message saying that the email was not delivered. So Shannon's idea of actually requesting a delivery receipt is a smart one, if you're not going to be regularly checking the size of your attachments. The board's subject number on this issue says that you in the subject line of your email, you need to have the claimant's name or the WCB number. I wouldn't put or, I would do both, simply because we know how many things go into it's like the board's digital nether world, where they don't get associated with the right claim, because there are just so many thousands of claimants. You're likely to not be able to get the document associated with the proper claim if you only use the claimant's name.
I also like to make sure all the attachments have that written on them as well, if I can.
Oh, absolutely. That's a good point, because the scanning service for the board is a separate entity, I think, than the
I believe so.
than the examiners, who I think are the ones who associate emails. And if the board number isn't on there, then again that could be in the board's digital nether world as well. Purgatory. There's also some guidance on what to do when submitting forms for multiple claims for the same claimant. This happens frequently when you have like a Section 32 that references multiple claims or an appeal or an IME. The board has requested that you do have to submit a separate copy to each of the form for each claim. I would not put multiple board numbers in the subject line. You should do a separate email with the board number for the claim that you're trying to submit your form to, and the board also indicates that you should underline or circle the relevant WCB claim number on the form if multiple claim numbers are referenced. Next. For helpful hints, I also just wanted to review permissible contacts with providers. I think that this is a really powerful tool for us to use in reaching out to claimants' attending physicians, as long as we're ever mindful of workers' comp's law section 13A6, which prohibits, it makes it actually a misdemeanor, any attempt to improperly influence the medical opinion of any physician who has treated or examined an injured employee. I would note that section also contains a very little used caveat, which would permit a carrier or employer to have an individual present at the evaluation, and that is, let me read the language of this section directly. It shall not constitute interference or improper influence if, in the presence of such injured employee's physician, an employer, his carrier, or agent should recommend or provide information containing rehabilitative services. So I'm not sure yet how I want to use that. I mean, I think that we're going to, you would want to use that obviously at a time when you're approaching permanency. I had an interaction recently with a client who the doctor said that, well, if I find out that the claimant is refusing vocational rehabilitation, I'll release him to return to work full duty. And I thought, well, that would have been the perfect time to have gone to the claimant's doctor and in the doctor's presence offer the claimant some vocational rehabilitation services. Because what happens to us when the claimant's represented, we send out a correspondence offering voc rehab, and we hear crickets from claimant's counsel. So for those, keep that tucked in your pocket. I would ask our clients out there, and if you have a situation where you think we might be able to use that to our advantage, please give me a call, because I'm eager to attempt to use that. Back to permissible contacts with doctors. Parties have a right to communicate in good faith with healthcare professionals regarding the injured worker's treatment and their condition. Just to be safe and to ensure that you're avoiding the appearance that you're attempting to influence the doctor, you should, if you intend upon calling the doctor, notify opposing counsel that you're going to contact the doctor and what you're going to contact the doctor about. You do not have to request permission. You have a right. The board's subject number says you have a right to talk to the attending physician regarding the claimant's condition and treatment. However, if you want to make sure that you're not saying to the doctor, like, "Doctor, how can it be possible that he's able to care for his children every day, but he's unable to return to work at this typing job?" So again, we need to be ever mindful of Section 13A6.
Save that for the deposition.
Right. Save that for us. And then, of course, if you're going to contact the doctor by letter, then it's imperative that you both copy the claimant's attorney and the board on that correspondence. Next. We're number one. We're winning. We're sick of the winning. New York is winning the highest costs in the country. We recently surpassed California as having the highest workers' compensation costs in the country. Our costs are at 181% of median costs nationwide, and that's up substantially from where we were in 2016. This is likely as a result of our schedule loss of use awards. And in New York, we pay $3.08 for every $100 of payroll and workers' compensation costs. That's 3% of the payroll for all the employees in New York State. It's pretty substantial. And next, you can read about studies like the Oregon study, which concluded that New York has the highest workers' compensation costs in the country, in the New York Workers' Compensation Forum on LinkedIn. This is a group that I started in, I think it was 2009, that has grown to in excess of 1,500 members. And I moderate the discussions, although LinkedIn recently changed its group rules, but I work very hard to limit the discussion topics to articles that I believe are relevant to New York workers' compensation stakeholders. So I would invite everybody to join the New York Workers' Compensation Forum if you're on LinkedIn, and if you're not on LinkedIn, consider joining just for that reason. Next. Our final bit of gossip, dishes, scoops, news is regarding a really significant amount of turnover in the Buffalo district with our judges. We had 4 judges leave in the very recent few months. Judge Malik retired, Judge Jakonski retired, Judge Walsh retired, and Judge Bannister, who was was an active workers' compensation law judge, has been appointed as the supervising law judge for the Buffalo district. So we had 4 vacancies for workers' compensation law judges in the Buffalo district, and new Buffalo judges, a couple have been appointed. One of those judges is Judge Mark Steiner, and another one of the judges is Judge Megan Zaliga Pelzinski. Next. Which brings me to our sad but happy news to congratulate Megan Zaliga recently, now Pelzinski, because in addition to becoming a judge, she also got married. But we wish Megan the best in her new position with the board as one of the newest Buffalo workers' compensation law judges. We're thrilled for Megan. We're devastated for us. But we feel that we're pleased that the board is promoting and bringing on to its stable of judges in the area someone who we think is going to do a fantastic job. She cares, she is smart, she researches the law, she's passionate, so we couldn't be happier for Megan despite how we feel about our own loss. So we'd like to congratulate Megan. Anybody out there wants to go, we're having a happy hour next Saturday at Santora's. We're going to give her the good LOMAD send-off. So best of luck to Megan. Next. And that concludes today's presentation of Status. It's Complicated, our newest On the Bench episode. And we'd like you to stay tuned to next month's On the Bench, topic to be determined, as well as the LOMAD players who will be presenting for you. That I believe it may have been scheduled to occur on November 23rd as the fourth Friday of the month, but because that's the Friday after Thanksgiving, we're going to pull it in instead on November 30th because somebody gave all these people the day off. I don't know who that could have been, but they have it off. So thank you very much for tuning in. If anybody has any questions from the chat function, I'm going to tap Najee, our fantastic. Are you a producer or a director or both? Both. I'm going to ask Najee to let us know the questions that may have come in on the chat function.
Before I get to the question, M. Busick says...
Michelle.
Yes, in regards to the virtual hearing, says, yeah, now we can use your firm on all the files.
Hey, I can't help it that we have smart people watching this show.
In addition, Mark J. says, the question arose here about emails to the board. We are concerned that they are not secure and some forms have social security numbers on them.
So when you say this, the forms have social security numbers on them, whether or not you have to redact those numbers or not is a protocol that each individual office is going to have to determine for itself. So I myself have recently contracted with a company to help me up my cybersecurity profile as a result of work that we do for a very large state agency in New York. Which has extremely stringent cybersecurity protocols in place. So I do believe that this is a concern. However, it's really beyond the scope of my skills as a litigator and workers' comp defense attorney to provide you with any specific guidance about how you can best secure that information. I can certainly provide you with the resources that I use, and I would be happy to discuss that further with you if given your concerns.
We did use encryption when we were at Special Funds when we did that because after the more recent legislative changes, we were essentially part of the board and kind of overseen by them, and they kind of dictated where and how we were sending things and in what format in order for it to be secure. Mm-hmm. And there was a change around, I want to say like 2015, 2016, where we had to start using encryption stuff.
So I have done some research on the exposure for liability when personally identifiable information is accidentally released. And it's not as draconian. The remedies that you have to provide people are not as draconian as you might think, and the efforts that you have to take in order to safeguard information are also not as you might want to as a consumer or as an individual whose personally identifiable information is being transmitted might like to think that they are. It's a complicated area, but certainly it is very astute of our audience to be aware that these are concerns that we should address given HIPAA and the very real danger that people can have in having their personal information exposed with identity and which leads to identity theft. Any other questions? No? Okay, great. Well, thanks again for tuning in, and we look forward to seeing you next month for our next installment of On the Bench. Have a great day, everybody.